All right, so to just start off, Mr. Vogel, would you mind just doing a roll call to establish quorum?
Certainly, Madam Chair. Ms. Dawson,
Present.
Mr. Esme,
Present.
Ms. Evans,
Present.
Mr. Tatum, Ms. Williamson, Ms. Williamson. All right, Madam Chair, 3 of the 5 members are present. A quorum is present.
Thank you. So I just would like to note that a copy of the April 18th meeting minutes have been posted to the task force website. If anybody has any corrections or edits or additions, please let us know now. Okay, hearing no objections, then I will declare that the minutes are approved. All right, so I know we're waiting on Dewan, but I kind of just want to get us going because today was supposed to be at least our last full day of permanency. And I feel like with the work that has been done over the last few weeks, I'm kind of feeling hopeful that maybe we can kind of get through some of these actual permanency issues and even just kind of start getting things on paper and things like that. So, I am going to Josh, in between the last meeting, Josh and I have talked a few times and sort of went through and tried to do a breakdown. I understand DHS did send over their breakdown of the Adam Walsh, as well as the Child Care Development Block Grant, Family First Prevention, and the Head Start. I think that those were helpful. Of course, they don't give us the specific statute numbers as to how that applies under 245C.15. But I think with the work that was done over the last few weeks, I think we can kind of make some progress on that. So what I'm actually going to do, if I can, is share my screen and share a document, and hopefully not share a whole bunch of other stuff. Okay. So I have shared my screen and I just, Josh, just so you know, I took the document that I think is kind of a compilation of both what I started and then what you definitely firmed up for us. But then I also just sort of added in bullet points from sort of the main things that I think are topics we've been talking about. Again, I think you've all been with me long enough to know that I like to just start putting things down on paper so that we can kind of
Love that.
keep going and keep doing all of that. So the top portion, again, are literally bullet points just to sort of bring us back to where we had been for the permanency topic. Then what Josh really spent quite a bit of time doing was really breaking down the Adam Walsh, which, just so that I can kind of be clear, I understand the DHS has some of these others, the child care, children's residential, and Head Start, but just looking at those charts, they still seem to really encompass the Adam Walsh. I wasn't noticing anything that actually stood out to me that might be different from, I think, really what I saw, other than, I guess we can get into that some, but I think to me, it looked like a lot of the offenses, the DQ bars and things of that nature are still, for the most part, really covered by what's under the Adam Walsh, with perhaps a few exceptions. But so just to kind of start here, we broke down the Adam Walsh because the Adam Walsh just really gives us sort of these blanket terms as to what's really required for the permanent bar. And so just kind of as we're looking at this here for the purposes of our discussion, we've got the felony convictions for child abuse or neglect. So really we're looking at the felony offenses of malicious punishment and neglect or endangerment. For spousal abuse, oops, sorry guys. Hold on, my phone is ringing. I don't know how to ignore. Sorry, apparently don't know how to operate my office phone. Okay, so then we've got the domestic assault and domestic assault by strangulation. And then again, for just additional crimes against children, including child pornography. I think that this was really helpful. And what Josh went through and did was kind of took the list you had started, Gina. So I think this is really a compilation of everybody's work and help. And sort of.
Yeah, I was going to give a shout out to Gina.
Yeah. I think this has been really helpful. I think we've all kind of come together, and this is a sort of a happy marriage of all of the work that we've been doing. And then we've got Josh did a really good job of sort of going through and highlighting then, and I apologize, I think I just scrolled fast, but some of these sort of what specifically applies, just so that I'm sort of clear. And once we're done with our meeting today, of course, I'll share this document. We can email circulate it so that everybody has it. The biggest ones that kind of stuck out to me was that as we're looking down in this next one for crimes involving violence, including rape, sexual assault, or homicide, but not including other physical assault or battery. Sort of the few that kind of stood out were that right now the statute just says criminal sexual conduct in the 5th degree. And to be really clear, when you break down that actual statute, only subdivision 3 is actually the felony level conviction. Subdivision 2 is a gross misdemeanor. And subdivision 3, when you break down for the felony, I actually went through and looked at it, as I'm sure, Josh, you did as well. But many of the other crimes that get you up to that felony level are ones that are actually already covered. So in some ways, it's sort of like a catch-all. Josh, I'm sorry, I didn't see you had your hand raised. Did you hear me?
Yeah, I was just going to kind of clarify what my red notes here are. Can you guys hear me?
Yeah.
Mm-hmm.
Sorry, I think I'm having a little bit of a unstable connection. Can you hear me if I turn my camera off?
Yeah.
We can hear you the whole time.
Okay, I'm having trouble hearing you now, but I'm just going to assume that you can hear me and get my point out quick. So everything that are on these lists are statutes where there was at least part of the statute that I thought fit the definition that we had from the Adam Walsh Act. The Adam Walsh Act definition doesn't give us a lot of help because it uses terms that are not specific to particular crimes without defining them. But I purposefully took a really sort of broad interpretation of what like the term sexual assaults, rape, crime involving violence would mean, on the assumption that, you know, really the only things that we would maybe want to drop out of the Adam Walsh Act bucket were things where we could really clearly say this is not required.
Yeah, no, and I think that was really helpful.
And I'm going to reset my internet connection. You guys should keep going if you can hear me.
Okay. All right. So yeah, and I think that what Josh did is really helpful. I also just think from a standpoint of a visual of really breaking it down for all of us. So just to kind of scroll, what probably makes it easiest for all of us is he did break it down then. So what would not be a permanent, but is currently under our permanent, which would actually be a 5-year, would be these felony offenses for the domestic assault where the victim is not a spouse or a child, because keeping in mind that our domestic assault statutes can cover Minnesota's domestic assault statutes can cover other individuals. Assault in the 1st or 2nd degree, assault in the 3rd or 4th degree, and then just the drug-related offenses. As far as the disqualifications that are not actually under Adam Walsh, like I had highlighted from the beginning, the CSC 5th degree subdivision 2, where it's a gross misdemeanor. I guess theoretically under our current statutory framework, that would put it at the 10-year DQ period, if I'm not mistaken. The CSC, where it's the predatory conduct, and he specifically highlighted where we're looking at where it's assaults 1 through 3. And I did pull that actually before this meeting just to kind of look at it. And the predatory crimes, again, to me, the way I view that one is it seems to be almost more of a catch-all, because it actually has to come with a companion crime. So that's where the companion crimes would be any sort of homicide. We're looking at the first, second, third, fourth degree CSCs. So it's, again, kind of a catch-all, but it does have this assault 1 through 3. Incest. Another interesting one that at least stood out to Josh and I was just the violation of the predatory offender registration law. Great bodily harm caused by distribution of drugs. Again, the solicitation, inducement, promotion of prostitution. And Josh is back, but I believe that that's more the adult ones. Kidnapping, I think kidnapping, there are certain portions. It's, again, the elements of it, the felony level harassment or stalking, aiding and abetting, and then the disqualifications that are based on other determinations, such as judicial determinations, preponderance of the evidence, which, just to remind all of us, we will be getting to that one next. As our next topic once we're done with the permanency and then the juvenile delinquency adjudication. So,
Lucas, is this kidnapping, the 60925 is the false imprisonment with intent to confine, which is not children, right?
so kidnapping is actually its own. False imprisonment is different.
Okay. So
sorry,
this is children then?
No, so kidnapping has a child element, which was why I actually, there's some question marks by it, because I think both Josh and I were kind of going back, sort of thinking about that one. Hold on, I had actually, oh, here it is. I printed the kidnapping one this morning. So the only thing, I think kidnapping could go, it depends on if it's subdivision 1 or subdivision 2. Subdivision 1 is when there's no bodily harm. Essentially, the person is held and then they're returned. Subdivision 2, however, is where the individual suffers or the victim suffers great bodily harm, or the person is under the age of 16.
Okay.
So I do kind of, I think it's definitely.
I think looking at it again, it should just go under crimes involving children.
Okay. And I think, would you agree, specifically if it's subdivision 2?
Yeah.
Okay.
Even one is.
Yeah, I think if it's kids, it's just going to be Adam Walsh. I don't think there's not any arguing about it. But the false imprisonment with intent to confine is one that's permanent, I think, and is registerable and has that 10-year registry, which is horrible. You rob a drug dealer and you have to register as a predatory offender for 10 years, and it messes with people's ability to work. It's a terrible thing. And I would love to talk about it with the legislature, because it's
And which one is that, Gina? I'm so sorry.
false imprisonment with intent to confine is a registerable offense. And it's one of those that you don't have to get even convicted of. Just even being charged with it makes you have to register. Like if you're charged with it and then convicted of any other felony, you have to register as a predatory offender for 10 years.
Well, but I think under at least what we have right here, and I'm looking for the false imprisonment.
I didn't see it. That's why I wondered if it was like considered kidnapping.
Yeah, it's not on there. It's not on there because it's a 15-year disqualification. So it's
like I didn't see it on the list.
So the
at
way
all.
that would, yeah, it's not on my list. Can you guys hear me?
Yeah.
It's not on my list because it's not a permanent disqualification under 245.
Oh yeah. We're not talking about that yet. Yep.
It's a 15-year, but it does. And there's probably nothing we can do about this, but what ends up happening with those folks is even though they're convicted of something where the charge itself is only a 15-year disqualification, you're right, they do usually have to register. And if they have to register, then that triggers paragraph F under the permanent disqualification section. So they're not registering based on the crime that they're convicted of. They're registering, or they're not permanently disqualified based on the crime. They're permanently disqualified based on the registry.
Yep, failure to register.
No, it's not the failure to register.
The
Yeah.
registry itself.
Yep.
Which, and I think I'm just gonna sorry, I'm looking for my paper here. I have a whole bunch of papers spread out all over.
And I would really love to address that, because there are often times that it's,
well, right. Think about how many people have to register just simply based on what they were charged versus the actual
Actually,
conduct.
maybe this is something that we should get some clarification from DHS on, because the actual language of paragraph F, it's interesting because it's situated under the permanent disqualification subdivision, but the language is they're disqualified if the individual is registered or required to be registered. And so I wonder if once you time out of the registry, if there's no basis for the disqualification. So it's permanent as long as you are currently registering. But if you had to register for 10 years and you successfully completed the period and no longer register, maybe DHS isn't even applying it at that point.
That's an interesting question, because if you think about it, the people who would be the permanents, they're all well, I guess not all, but I guess that's an interesting question, because there'd be the underlying, the permanent one would usually be an offense that's probably a permanent bar anyway, if that makes sense.
Maybe, but we've got this really broad language in our registration requirement where you are required to register if you are convicted on any crime arising out of the same set of circumstances for a charge or registerable offense that there was probable cause for.
Right.
So, I mean, you could get and I think we've talked about this before, and I'm hearing people saying yes, but just to complete the record here, we have people who are required to register for much more minor crimes that they reached as a part of a plea bargain, just because they were charged with something that was never proven and never admitted, that would have required registration if it was proven or admitted.
Which I did notice, I went through that registration proposed recommendations. It seems like that seemed to be I thought that was one of the ones there seemed to be a concern, but I don't think there was enough of a consensus to make that a recommendation to actually change.
But maybe we could either clarify how DHS is currently applying that registration disqualification, and if they are permanently banning anyone who ever had to register, maybe we should suggest language that limits it only to people who currently have to register.
Yeah.
Perfect. So that would be a question then for Emily to take back, and what would the wording on the question be? Are they permanently disqualifying?
Yes,
Or
is
just
somebody
during the registry?
I would ask it this way. Is somebody who formerly had to register but no longer has to register disqualified permanently under subdivision 1, paragraph F?
Emily, does that make sense to you?
Yes, Madam Chair and members, that makes perfect sense, and I'll talk with our legal team and get back with an answer for you.
That would be great. Thank you.
Thank you,
Appreciate
Emily.
the question. Yep, appreciate the question.
So, okay, so just kind of, I think to us as a group, then this 245, this 9, I don't know, I guess, how do we want to handle this, or what are people's thoughts? I guess, let me just back up here. So we've got these permanent DQs and these 5-year DQs. Hey, Dawn, that are, so Dawn, just to catch you up to speed really quick. So we have been talking about, because today is kind of our last full day for the permanent disqualifications. And so I have my screen shared, which has a document that kind of is the product of, I think, everybody's hard work, definitely something that Gina started, and I think Josh and I have added to, but that really tries to break down our permanent DQ list as to what is actually required by the Adam Walsh. And so just, I'll kind of scroll back up here just so you can see. And at the top are my notes, just to sort of bring us back to some of the ideas we were talking about last time, so that we have it at least in writing and just sort of starting to concretely think about it. So the first, just under the Adam Walsh, the permanent bars are, it talks about felony convictions, but felony convictions for child abuse or neglect, spousal abuse, crimes against children, and Josh very nicely broke it all up as to what's actually under our permanent DQ using the Minnesota statutes. Crimes involving violence, including rape, sexual assault, or homicide, but not including physical assault or battery. And then what are only 5-year bars, not permanent, but 5-year bars under Adam Walsh, where we've got the felony offenses for domestic assault, where the victim is not a spouse or child, the other assaults, and then the drug-related offenses, as well as then the current permanent DQs that are not actually even Adam Walsh offenses. And so we've kind of tried to break that down, and that's what this is. And what I said was, once we're all done for our meeting today, we'll definitely, however we edit this document that's at least started, of course, we'll circulate it amongst the group so you all have it and can digest it more. So I guess kind of the last thing before we start maybe editing and trying to do some of this is, under our permanent DQ statute, there is sort of this random bullet point that says the United States Code Title 42, Section 9858F, which looks like, then this was where it was super helpful to get this from DHS, is the Child Care Development Block Grant. So these are child care staff members. And anyone who has, I'm just looking at the DHS handout here, but where the activities involve supervision of children for a child care provider. So, and I think what's interesting is, even as we look at this one, this is where I did notice at least a few differences, as it does list arson and specifically kidnapping. So I think we've touched on at least the kidnapping. I do believe, Josh, you had put 1st-degree arson for sure on there.
Yeah, I left it. I don't think it's entirely clear that arson meets the crime of violence definition that exists in the criminal section of U.S. federal law. But I'm not sure on that. I just don't know if setting a fire is physical force or not. I assumed, though, especially given that it was in this list anyway, that it was probably safe to just say setting a fire is a use of force, and I kept it on the permanent DQ.
Yep, no, that makes sense.
It's considered as a violent crime anyway, isn't it? Like a violent crime, like if you burn somebody's business down or something, or is it a burglary classified in that, or what is it?
So the thing, and we talked about this a little bit, DeJuan, the Adam Walsh Act doesn't give us a definition of crime of violence. There are other definitions of that exist. There's a definition of that term in state law. There's another definition in another part of the federal law. I use just as sort of a guidepost, the definition from federal law, which talks about use of physical force against a person or property. And I guess I thought maybe there could be an argument that that setting a fire doesn't meet that, but I thought probably it was an argument that was not going to be super convincing to most people, so I just left it as
So is it connected with kind of like a terrorist act or something, or making it seem like?
Nope, it's just simply, is arson a use of force against a person or property? Is setting a fire a use of force?
Well, and it's specifically physical
Force, right?
Yeah.
And I don't know. But I kind of thought that, like, if we're going to end up making a recommendation to the legislature that some of the crimes that are currently requiring permanent disqualifications are overbroad and don't need to be there in order to be in compliance with the Adam Walsh Act, we should have that list be as like airtight as possible.
Mm-hmm. Right. And I think so. And what's interesting here on this list then is this does put the drug offenses at a 5-year as well. So I think that's consistent with the Adam Walsh. What doesn't appear to be consistent is this one lists a permanent as physical assault or battery, which Adam Walsh does not. So I think that
Adam Walsh would only be
a 5-year.
Yep.
Right.
Yep. It specifically says not battery or physical assault on Adam Walsh.
Well, and interestingly enough, the violent misdemeanors on here are permanent.
Right. And that could end up being really broad.
Yeah.
I mean, it's a violent misdemeanor committed by an adult against a child.
I mean, I think that's going to be your malicious punishment and your child endangerment and perhaps a domestic assault if it's a child.
Right. Or I would say even a 5th degree assault if it's
even a 5th degree assault against a child. Yeah, I'd agree with you.
What is this United States Code Title 40? What is this?
I think it's the block grant.
Okay. And that's only for child stuff.
Child care.
Okay.
So I think we're, as far as I can tell, we're basically in kind of the same box with this section 9858 as we are with Adam Walsh, where, like, if the state wants to get at that federal pot of money, we got to follow, their marching orders on background checks for things that involve that pot of money, right?
Mm-hmm.
So I guess the question is, for us, do we want to create a separate bucket for this 9858 that is similar but different than Adam Walsh and applies in a more narrow set of circumstances, or do we want to just mash them together?
I have a really quick question though, based on this. So Emily, so if we have provider types, like treatment provider types that have licenses that are for, like, Teen Challenge, for instance, that are licensed for 16 and up, and we are getting answers back that say that it's too soon or whatever. This could be the reason why. If they're drug offenses that it hasn't been 5 years, then that would be new stuff, right? From like changes from 2019, that it hasn't been 5 years from drug offenses.
Yes, Member Evans, I believe that is, I'll double check. But there were some significant changes in 2019.
And this is part of that Title 42. And if we're licensed for 16 and up in some of those buildings instead of 18 and up, that would make a difference.
I believe I will double check for you just to make 100% sure.
Interesting. Okay, thank you.
I think,
welcome.
Dina, those are, I think because there's the second, so we've got under the child foster care and adoption, which is the Adam Walsh, the child care, which is this block grant. And then the next one down are children's residential
Yep.
facilities.
Yep.
And those, it looks like, specifically follow Adam Walsh. So I would imagine that's, or, and I think if Emily can confirm maybe with DHS, but to me, that seems like that's where that, or maybe you guys qualify under both. I'm not sure.
Yep. Yep. I was looking at this thing today and saw that drug related offenses are on there, and it just made me wonder, because definitely something changed right before COVID, where we were all of a sudden getting a lot more recency disqualifications that I was having a really hard time understanding. And so if that's the case, this makes more sense, because it says right in this thing for oh no, you're right, it's under child care, not children's residential facilities in this chart.
Yeah, but children's residential facilities would still follow the Adam Walsh, which drug charges would be 5 years from the
From date of incident. Okay. Because that's what they're coming back for, and it says recency, and I'm like, recency, they've been clean 2 years or whatever, and so that makes sense.
Yeah.
Then okay, perfect, thank you.
Yeah, so kind of back to, I think, what Josh was sort of proposing, and I'm just gonna scroll up here, so everybody bear with me. I don't want to scroll too fast so that everybody kind of gets a little discombobulated. But so kind of going back up here, then I think Josh's sort of initial question, Phil, kind of goes back to, we've got these separate background studies where we've got the Adam Walsh compliance, the alcohol, the family caretaker, and the other vulnerable adults. So I think, Josh, your question is sort of, do we create a fifth bucket, or is it essentially, does the Adam Walsh Act, I guess, almost transform into, to me, it just, a broad stroke would essentially be anybody who works with children. And I guess definitely looking for feedback. And I guess I can even just start with, my only concern would be if we create too many buckets, it can get confusing versus, I just, to me, I get worried about making it too confusing and then too complicated, and it just creates chaos.
So the one place that the two are really going to differ, right, is with the felony assaults.
Mm-hmm.
So we have an opportunity to stay in compliance with Adam Walsh Act while removing felony assaults as permanent disqualifiers. But if we combine, we create a total bucket for working with children and getting federal money, then I think we have to put the felony assaults back in. So that's sort of the trade-off. The ease of use of having all of the federal child worker, money all in one bucket, versus being able to let people pass Adam Walsh only background checks with those felony assaults. My preference would be to take as much, to eliminate as many permanent disqualifications as we can. But what might temper that, I guess, is if all of this money is, I don't really know how, I don't really know much about how the state is getting money through these federal programs. And if 9 out of 10 cases, you've got to pass both anyway, then it might make sense just to create one bucket.
And I'm wondering, Emily, is that is that a type of question that DHS could answer fairly easily of how often are people having to pass, the Adam Walsh as well as the child care, can we get kind of percentages of would it even make sense versus just if you're going to be having to go through multiple anyway, just keep it simple. Does that make sense? I realize I don't think I articulated that as well as Josh did, but just if that is an answer we could get.
I'm happy to check, and I'll check with a couple different sources just to see.
Okay.
Our teams, just to see what we can do.
And I don't know that and I don't know that we need like full numbers and a full kind of deep dive, but I guess.
Yeah, and here is just my pushback on that a little bit, Josh. And this is putting on my conservative hat and like knowing how the other side is going to react to that. Like when you add, take them completely off first and second degree assaults, which are generally pretty violent crimes. Those individuals, just like with a drug crime, are able to, after a year or 2 years, still on probation, able to apply for a set aside with no restrictions. And so I just don't know that that like those recommendations are going to be, I would hate for recommendations that are viewed as like off the wall to get in the way of recommendations that we make that are like seen as viable. Do you know what I mean? And so that's why, like, they already have this 10-year bar where there's crimes in there, and I don't know why they're in there. We don't have that on our list of stuff to look at, because I'm still super confused about some of the things that are in that 10-year bar, because like first degree drugs are in there for some reason, and I don't know under what circumstances that they're in there, but they're in there for some reason, that list of 10-year bar. And so that's why
I know why that is.
Yep. And so that's why I feel like we could add some of that stuff that's not very palatable to some folks into that 10-year bar and get them seen after a certain period of time.
And Dawan, I see you have your hand raised.
No, I was just piggyback. My tooth is killing me, so you guys bear with me over here. That's coming out here this week. But I just wanted to add to what you were saying, Gina. Like, this is what I thought I heard, like with the like with the probation and not being able to figure that out. I was on parole. Like when I first started going to school, I had just got out of prison. Probably was out like 6 months or something. I got to do something. I can't just be working on a job. And they approved me. I got approved for a set aside, work under supervision. And so you get it. It was a lot easier back then. Now I'm having trouble now. Yeah, when I really wasn't trying, put it that way. Just trying to find my way.
Josh?
So I guess I just want to make sure, because Gina, I totally get what you're saying about wanting to make sure that our recommendations here are in the ballpark so that we don't just get ignored altogether. What I'm talking about though is just the things that will require permanent bars, having them not require permanent bars anymore. So that doesn't mean that they wouldn't still be disqualifications. I think they would get moved to, whatever disqualification category we have that is a step below permanent. And so like, I think it would, so like if we imagine, a first degree assault or something, they would be in, whatever bucket. Like right now, it would just go into the 15-year bucket. I don't know if we're going to keep the 15-year bucket, but like that's where it would be if it didn't have to be permanent for the purposes of the Adam Walsh Act.
Yep.
Does that make sense?
It does.
Is that consistent with how you were looking at it?
yes, I just worry about some of those. Like, I just know how, like, and just to be clear, I don't disagree with you guys. I
Okay.
just am seeing it how I know others are going to see it. Like, I always want to be clear about that.
Yeah.
And so, like, I just don't think we can stick those higher level of violence in with, like drug crimes or whatever. Like, we have to figure out a place to put them that's different than that, because they are different. You know what I mean? So yeah. And so what does that look like? And so I would like to hear about how are they using that 10-year bar? Like, why are drug crimes in there? I would like to understand that better, Josh.
So everything that is in the 10-year bar is there because it's a gross misdemeanor conviction. And so anything that is anything except for a few things that are in the permanent bar category, most of the like felony level charges that would otherwise be 15-year disqualifications, and some of them that would otherwise be permanent disqualifications, get downgraded to the 10-year disqualification bucket if the sentence that was imposed is a gross misdemeanor instead of a felony. So like, if you could get charged with a felony, but then like through the plea bargain or even through a really good sentencing argument, end up with just a gross misdemeanor conviction. And if that's the case, it's a 10-year disqualification. So theoretically, you could have, first degree drugs that got a gross misdemeanor sentence, and then it would trigger a 10-year disqualification. And then I guess the other thing specific for drugs is in the like drug reform package that was like 6 years ago or so now, we actually created a gross misdemeanor 5th degree for it's basically the trace amounts category. Like if there's just like, less than a gram of cocaine or something.
Mm-hmm. Yeah, that's not what's in here though. It's like criminal vehicular homicide, 1st degree drugs, simple robbery, assault in the 3rd degree. Like, so you're saying these are all misdemeanor crimes that are in here?
No. If you look at it, the very top of the long paragraph, right? It says an individual is disqualified under the statute if less than 10 years have passed since the discharge of the sentence imposed, and the individual has committed a gross misdemeanor level violation of any of the following offenses. So all of the offenses that are in this list, even if on their face they're felony level charges, if it's a gross misdemeanor level offense, which occurs when the judge imposes that lesser sentence on you, then that's how you end up in the 10-year bucket.
So why is it called a bar and not a disqualification? Is it the same thing? It's just 10 years and like, what's the difference?
I think the language that the statute uses is disqualified. And we've been using bar to refer to specifically the provision that bars people from getting a set aside once they've been disqualified. So like, think of the first gate as, are you disqualified or not? When we're talking about that, that's going to be, are you convicted, or is there a preponderance of the evidence for one of the offenses listed somewhere in 245C? That question, that's gate 1. That's, are you disqualified? And then gate 2 is, can you get a set aside? And most people can get a set asides, but the permanent disqualifications create a bar to a set aside.
So these individuals are unable to get a set aside for 10 years.
Yeah, under current statute, under current statute, it's the bar to a set aside only applies to people who are in the permanent disqualification category.
The bars are under 245C.24. So I think where the confusion is coming is it's 2 separate statutes.
Right. Well, yeah, yeah. But the bar applies only, as far as I know, and maybe there's some other bar somewhere that I'm missing, but I think that the bar applies only to the permanent disqualifications, and it does apply permanently. Those people can never get a set aside. So they're permanently disqualified with no hope of a set aside.
So, and that's under 245C.24. That's where it added subdivision 2. There's a permanent bar to a set aside. And then the subdivision 3 is the 10-year bar.
Oh, and then Gina, is part of maybe what's creating the confusion is that I put permanent bar here on the Adam Walsh part. Because I think that's the other thing is that the permanent bar is required for Adam Walsh Act compliance. The Adam Walsh Act compliance doesn't seem to create a provision to give a set aside to waive it.
Yep. No, the thing that I'm just like, so I think what I think is accurate is that when you look at like the data set, DHS data set 3 table that we'll put together, he's got permanent bar, 10-year bar, and then 15-year disqualification, 10-year. And so I'm just looking at like these 10-year bars, and it is what I think it is. Like these people that got these controlled substance crimes in the first degree, there's less than 10 of them, are unable to apply for a set aside for 10 years.
Which to me isn't even consistent with Adam Walsh or what's required by the childcare ones, which is interesting.
No, it's ridiculous actually, because if what you're saying is true, that they were convicted of a misdemeanor offense, then why would they be barred from applying? That doesn't even make any sense. The people that got felony convictions are able to apply for a set aside. Like, I don't understand why these people are on this list. Let me share my screen.
Okay, I'll stop sharing mine.
Like I don't know.
Hi, Tashonda.
Hold on. I don't know how to get out of here.
Hello, Madam Chair and everyone.
All right. How do I share my screen? Oh, there it is. Big green button in the middle. So this is the I am terrible at this stuff, so that's not what I meant to get rid of. So do you guys know where this is? This is, there we go. So this is so these are the permanent, and then this is the 10-year bar. And do you see the stuff that's on here? And then these are the 15 years. And so if that's what you're talking about, and this 10-year bar is they're barred from asking for a set aside like that.
So I'm going to guess that we just have a confusing heading here. And this heading should be 10-year disqual. Well,
this is
what's the 10 DQ 18? Yeah, what's that?
So these are the 10, these are the gross misdemeanors.
Yeah.
12 disqualifications. And so I would like some clarity on this. If somebody could figure this out, I would really appreciate it. But I think this is like this bar that they're actually barred from asking for a set aside for 10 years. Emily, do you have any idea what this is? These bars?
So the bar does preclude an individual from getting a set aside. So there's a distinct difference between the two. Would it be helpful if I could get legal, our background studies legal team to give you just a real clear-cut definition of the two, because they're distinct.
Well,
Yeah.
I think we got that, Emily. I just think we're wondering what's the basis for a 10-year bar, because we only know about the basis for a permanent bar.
That I'm not sure and can check and find out.
And they changed substantially what's kind of on here a little bit between 2018 and 2019. It would be great if somebody from that team could come to one of these meetings and maybe be ready to answer some questions for us. I feel like we have quite a few at this point.
And I think, and if I could just sort of jump in here, just to kind of keep us on track, I do think that some of these set aside questions and what's a bar versus not a bar, and quite frankly, whether we want to look at a different framework, I do think that's, at least in my mind, would fall under more of our remedies topic, which is going to be kind of a few out. So
Yep.
I definitely think important, but I think, Emily, obviously that gives you time to ask about it. So we're not rushing you. I know, because we've asked you a few questions today. So if I could even sort of prioritize those, I think number one would be if someone who formerly had to register but no longer has to register, is that a permanent DQ? And then also, if I think second priority would be how often you need to do the multiple background checks for the Adam Walsh, the child care, children's residential, Head Start. And then sort of third down would be these bars on the set asides, because I think that those are going to come more under what was our third bucket, the remedies. So I think there's a little bit more time there. And so Gina, I think definitely excellent thing to look at. And I want to make sure we don't forget that, but I do think 245C.24 is just a little bit further down the road.
Perfect. Thanks for keeping us on track, Lucas.
So,
Madam
yeah.
Chair, if I may really quickly, I just want to let you know with the data subcommittee, we have submitted a written request for someone from the data set team, someone from DHS that can give further explanation. So just know that request has been made, and we're hoping to hear back from them whether they're able to attend a task force meeting or just give us some available dates so that we can make sure all of the subcommittees and whomever else can be available for questions.
That's great. Thank you. And so I just want to also, I think we were technically scheduled until 12:30. I have to go to a different meeting here soon. So I am happy to either kind of briefly summarize where we're at, or see if we can sort of come to a little bit of a consensus on some stuff, and then either kind of pass the buck for a little bit, or if this is the type of thing, if I kind of put these notes together more formal, if it makes more sense to perhaps distribute the document that I was sharing earlier, so everybody can kind of digest it a little bit. I do know with the questions to Emily, the two kind of priority ones, I think those might also kind of give us some final guidance for actually potentially voting on recommendations. So I'm not sure what people kind of want to think about, or where we want to go, or what makes sense.
Madam Chair, if I may again quickly, I want to just make sure that we are looking into, when we talk about being conservative or not, that we're looking at the price, the fiscal amount to said backgrounds that we're looking at. I think that's going to really help to weigh it one way or the other in regards to interest.
And I think, is that information that the DQ subcommittee has requested?
Mr. Vogel can correct me here if I have this wrong. I know it's been brought up about being able to find out how much is being spent for these background studies and things of that nature. I don't know that there has been a formal request at this point.
Okay. And would that be something, I just want to make sure I'm understanding of, so I'm not stepping on anybody's toes. Is that the type of thing that would be more appropriate as a request from the data subcommittee to DHS? Because I got to imagine that seems to be a group as a whole question versus just specifically the remedies subcommittee. I'm just wondering. Otherwise, I'm happy to just put in the request and call it good. Okay. Well, I guess why don't does anybody else kind of feel differently? I mean, I do think we have the information on, I think it should be hopefully well, I guess maybe it's not a simple question, so I won't presume at all. I know we have the data on the number of background studies and things of that nature. So Emily, I hate to burden you with, I think, a fourth request.
Why don't we talk about that with John at the chairs meeting?
That's actually a good idea. I like that.
Yep.
Thank you. Thank you. I was looking for other ideas there. So Emily, I'm going to put you on hold on that one. All right. Thanks.
Sarah, I will be ready.
All right. That sounds good. We'll talk about it at our chairs subcommittee meeting and then probably circle back in one of the other meetings with you once we're more firm on that.
Okay. Thank
Perfect.
you.
Thank you. Thanks, Gina. Saved by Gina. So, okay. So just kind of to bring us back, as we're talking about this, and I'm just going to go back to the original notes. And again, I can definitely, share this and by email and just, it's definitely a bullet point and rough. But I think the big things that we're waiting for, as we had originally talked about the 4 separate buckets, I think once we can get that clarification from DHS about the Adam Walsh compliance and whether that needs to be a broader bucket or if we can actually separate it out, I think that will help answer some of those questions. I think other piece is the permanent bars. Again, kind of what we talked about, that's definitely something to be looking at. And whether it's a 10-year bar, permanent bar, or any of the other enumerated ones, that will be for a further meeting. So to me, I guess kind of where we're at, that I think we kind of need a final answer before maybe we can actually decide, is as we're looking at these, sort of the remaining question that seems to linger would just be whether as a non-permanent bar, we make a recommendation that assaults are not included in the permanent bar list or they are. And I think that that's just, once we can get that clarification, that seems to be kind of the main one that I think will help us sort of make those final decisions as to, and to me, it seems then we're making a recommendation of, hey, legislature, here's our recommendation for crimes that should be removed from the permanent DQ list. I think that keeps it simple and easy to follow. And so to me, I think our main question seems to be the question of assaults. What do people think? Does that kind of make sense? Any additions to that? Josh, I see your hand.
Well, I guess the other question that I had, or that I was maybe thinking we were going to get to, was once we've come up with the permanent disqualification list, which right now we were looking specifically at what needed to be on there for Adam Walsh Act compliance. But then the second question is, do we even apply that same list to those other buckets that we had identified that don't require Adam Walsh Act compliance? And I think my actual policy preference would be we don't apply it to anything other than the stuff that the federal law requires us to. And we basically just get rid of permanent disqualifications altogether. But barring that, maybe a little bit more conservative approach might be to keep the permanent disqualification list in place sort of generally, but exempt those other 2 buckets that we had identified for drug and alcohol counseling and for basically family member care programs, which were both buckets that we had sort of already identified as being sort of less concerning in terms of like a public safety concern based on the prior record, because of the nature of the work in the drug and alcohol counseling programs, and because of the family nature and the fact, for that bucket, the fact that there's going to be contact there anyway. So disqualifying them from receiving funding to provide needed care doesn't seem to make a lot of sense.
And we could actually give them both of those options.
Yeah.
Okay.
We don't have to pick one or the other. We're giving them recommendations. Here are 2 recommendations we're offering you.
Right. I think that makes sense. And I think that seems to be fairly consistent with what this group has definitely talked about. I definitely think this Adam Walsh and kind of figuring it out, it's felt like it's a lot of work, but I think it's not the most clear. And so sorting it through has just taken longer versus the others, which I guess, at least to me, feel like easier answers.
Yep. So, and just to refer back to the 2008 study that was done, they recommended removing all permanent bars other than those for murder, manslaughter, and CSC crimes. And so they recommended that as well. And like I said, like I would not be opposed to getting rid of assault 1 and assault 2 from the permanent disqualifications, but I think we should do something, when we get to that point, then do something different with them than to just throw them in the other pot. So,
and I think that makes sense. And I could see, again, a little bit of sort of this broad brush stroke versus, kind of keeping in mind sort of the reaction and the response, because keep in mind, we have to bring our recommendations first to the large group.
mm-hmm.
And so I can definitely see some pushback of a total removal versus I think a lot of people can probably get their minds wrapped around the homicide and at least the CSCs 1 through 4 versus the 5th degree.
Mm-hmm. Yeah.
I just wanted to say, like, it's crazy how we think like somebody killed somebody. Oh, I don't want to be next to him, but I'm like the people that I've been around that have killed people, like the remorse, the one that's actually changing and actually, because there's no getting away from it. You're living with that forever.
Right.
So.
No, and I'm with you, Juan.
Somebody said it before, but like somebody said, obviously they shouldn't be, they would be. And I was thinking like, shit, they probably be the best ones.
Yeah. We just can't fix that.
Believe me, I have
It's
represented.
I already know it ain't gonna happen. I was just saying that. Yep.
Yeah. No, I get that. And yeah, so there's a few clients who come to mind that, yep, I think they'd be fine, but
Be grateful as hell. You know that.
Yep. Gina, I see Gina and Josh, and I don't know who had their hand up first. I apologize.
I think Gina did.
Okay.
My hand was up from before, and Dewan, like the fellas, like Zeke just got out, and Kevin, and some of them homicide, and just even the way that they're done, like none of them guys even pulled a trigger, right? They were just there when it happened, but you know my heart. We got to tackle what we can tackle, man.
Yeah. I understand now. I've been listening, learning, and paying attention. Yeah. Hey, it is what it is. You just got to keep rolling with it, keep pushing, keep fighting. That's it.
Yeah.
Josh.
Just a couple of things to make sure we're on the same page. I'm going to again be advocating for the removal of the bar to the set aside for permanence. That to me makes those to me, everybody should at least be able to make the argument that they've rehabilitated and are safe. But removing the permanent disqualification itself, I do think, I'm with everyone's concern that I understand that is going to be a bigger ask, and I'm probably going to be on the outliers of people who would be comfortable with that. But just so we're thinking through how that argument would go and why I think it could be persuasive, is that there's still a disqualification. That disqualification doesn't even start running until the person is done with their sentence. So for our like really serious murder cases, they have to serve their entire prison sentence, including their supervised release period. Then once they're discharged, then they start the disqualification period. And then it's not until they're done with that, with nothing else intervening that would trigger another disqualification, that they would be sort of clear from my suggestion. And I just think that the argument would be, why are we having DHS do background studies in perpetuity for people who have had clean records for years and years and years and years, just because it's listed on a permanent disqualification list? It would be better, especially if we're seeing, high level of rehabilitation for those people, to just let them time out like anything else. It's because it's going to be so much time. Like, we're talking 20 years probably for most people.
No, and I see what you're saying, definitely. And I think that makes sense. And I think especially as our group is talking about trying to break it up, of, are you working with a child, where I think that you're just not going to get it, versus somebody who's working, let's say, in the chemical dependency realm, and it's a different type of scenario, and their background is actually is helpful. And it's really, so I totally get what you're saying. And I think that makes sense. And yeah, I definitely want to make sure that when we do get to the remedies, to me, I think those bars maybe are going to be agenda item number 1, just kind of as we're thinking about it. So, so I guess kind of just where that leaves us for today. I mean, I think we're pretty close to where we could almost be finalizing at least sort of bullet point recommendations. And maybe what makes sense is, in our next subcommittee chair meeting, I want to talk to Chair Geffen a little bit more about what exactly he's going to be looking for from our group. Because I think our group has been on point and able to come in with what we need. That I just want to kind of get some feedback from him as to how much detail he wants from us written, versus does he want us really just starting off bullet points, for the large group before really full recommendations are written. So I think before we go and put in a whole bunch of work and write up a whole bunch of really nice stuff, if he's going to say, no, don't do that. I think if everybody's all right with it, I will definitely bring that up. We meet on Wednesday morning, so I can bring that up to him as a question. And then, of course, once we can get the 2 kind of main questions that we need for the permanency list from DHS, I think once I have those answers, then I kind of think, honestly, we're close to finalizing whether it's bullet points or formal written recommendations for the large group on permanency. I don't know if anybody else feels different, but I think we're close. We just kind of need those few final details to finish it up.
We're doing it, people.
We are. So I think we're super close. I'm going to add in kind of just into this document a few of the comments that were made today, as well as the questions. And then I will email the document to you, Will, if you could then distribute it to the group. I'm going to run to my other meeting, so I'll get it to you after I get back from that meeting. But then we all have that and can kind of digest it. And once I get the answer from Chair Geffen, I can, through Will, we can circulate that so the whole group knows that before our next meeting. So that then we come in next time ready to kind of finalize whether it's bullet points or formal recommendations. Does that sound good, everybody? All right, we're staying on task. Perfect. All right, is there anything else from today? We talked about a lot, we've digested a lot, and we have more to digest, but we're close.
I'm just gonna, I got a report that I was a part of from the Justice Lab from Columbia University that I'm gonna send out to all the chairs. I just found it again, that has here's the data point and what we deduced from it or whatever. And then here are the recommendations that we're giving from that stuff. That it's a great format. So I'm going to send it out.
That'd be great. Yeah.
Everybody
because we're definitely,
for it.
Yeah, no, that would be amazing because I know definitely some of this stuff is a little bit of at least me making it up as I go. So I like to see what other people have done. So that'd be great. So perfect. If there is nothing else, I will watch for that. But if there's nothing else, then we are adjourned for today. Watch for some other stuff to come. Will, I'll get it to you as soon as I can. And then the rest of the group watch for some stuff from Will.
Yes, get to the dentist.
Thank you, everybody. We are adjourned.